12th anniversary of the Supreme Court about a month ago, and we were talking about crucial jurisprudence. He said, I have had to ask myself whether the highest interest is the public interest or there is a higher interest called the national interest, because the public itself could hurt the national interest. Public can be mobilized or mobilize themselves against national interest. First of all, where does this national interest sit in the Constitution? And number two, wasn't this an indirect proposal of a clawback on basic freedoms that are enshrined in the Constitution, Your Excellency? As you answer this, Your Excellency, you did say that lives of protesters need to be protected as you ensure public safety. Was the public unsafe during that period? Why did we get to that point?
When I spoke at the Supreme Court reflection colloquium on public interest and national interest, some erroneously thought I was talking about government interest or even security interest. That's not the case. In fact, after that colloquium, I've had further reflection, because by the grace of God, I'm also a scholar. So I reflect on some of these things, and I have come to the conclusion that within our constitutional framework, we can categorize three forms of interest that could be expressed by members of the public, rather than two, three. One is popular interest. And the question I'm asking myself as a scholar and a student of constitutional law is whether what is popular is in the public interest all the time. I am not sure. I am not sure that what is popular is in the public interest. I don't believe. Sometimes yes, maybe not all the times. But at the Supreme Court colloquium, I also asked, is there a hierarchy of norms in our Constitution such that we have public interest and national interest? And for clarity and avoidance of doubt, national interest is not government interest, and it's not the interest of, it's not security. What I had in mind is, you're aware, our Constitution allows the people of Kenya to express themselves in exercise of their sovereignty in two ways. One, through elections. Two, through referenda. And then I asked myself, in fact, it was tailored to the judiciary, and I wanted to ask myself, if the people of Kenya, for example, agree and express themselves in exercise of their sovereignty to change the Constitution in a referendum and vote to remove the judicial arm of government, and they decide we don't need the judiciary. People are sovereign. In a referendum, they can actually remove the judiciary. And then I asked myself, since this is an outcome of a referendum, this is in the public interest. But is it in the national, is it in the national interest that really you can have a modern country, a democratic country without a judicial arm of government?
But these are two different scenarios, DP, because this was about taxes that Kenyans felt were unfair, and their leaders
at the
were
Supreme
not
Court,
listening to
I
them.
was not talking about the protest at all. You can look at my statements. I was not talking about protest.
So what do you...
We were reflecting on what the Supreme Court has helped us to understand about our Constitution, and I was inviting the Supreme Court judges to start thinking whether, even as we express our sovereignty, we have what we call bedrock things that we cannot touch. I'll give you another example. If the people of Kenya meet and in a referendum, they overwhelmingly vote, so it is popular, it is in public interest, and they vote to change Article 4.2 of the Constitution that says that Kenya is a democratic multi-party state and creates a monarchy or another form of government that is not democracy, it is in the public interest. it is popular. It's in the popular interest. But is it in the national interest? My answer is that it is not. So within the Constitution, there are things you can change and still not change the DNA of our Constitution. There are others, once you touch them,